All right. Good morning, everyone. This is Tripp VanderWal, a member of Miller Johnson's Employee Benefits and Executive Practice Group. I am joined by my colleague, Brett Liefbroer, who will be monitoring your guys' questions. So with that said, I think most of you are probably aware, if you've been on these webinars before, please feel free to enter your questions into the Q&A feature, and Brett will be monitoring those and try to interject those where appropriate. This webinar will be made available on the firm's YouTube site, along with, and I believe our COVID site, along with a copy of the PowerPoint slide. So if you have to drop off early, don't worry, you can access it. It'll probably be on later this afternoon or by tomorrow. And we will take questions throughout the presentation, but also stick around for a few minutes afterwards and answer any other questions at the end. So as indicated on the screen, we are going to be talking about the IRS guidance that came out on Tuesday last week that addressed a lot of questions that at least I had or we had internally, and I'm sure many of you had, about these COBRA subsidies under ARPA, the American Rescue Plan Act of 2021. Just a few comments about the IRS guidance. It is IRS Notice 2020-31. It is in a question and answer format. It's 86 questions and answers, so there's a number of them. I think it's 41 pages in total. But the nice thing about it being in question and answer format is it is a little bit easier to read than some of the IRS guidance that we're used to. That's pretty complicated. So I encourage you, we are going to try to take you through some of the highlights here this morning. We also issued a client alert on some of the highlights last night that's available on our website. But I encourage you, if you have additional questions that maybe we don't get to, Google IRS Notice 2021-31 and take a look, and you may see some helpful clarifications. I have had some discussions with some IRS Department of Treasury attorneys. They are still continuing to compile questions in response to this guidance, and have indicated that they may continue to issue additional guidance in the future, especially if they see kind of a repetitive question come up, and they've already started to identify a few. So we could have more later. With that said, let's get started. So the first thing is, maybe I should start with an overview here, is remember under ARPA, individuals who are assistance eligible individuals, AEIs, are eligible for a COBRA subsidy that's equal to the entire COBRA premium for the period, their COBRA period that overlaps with the 6-month period of April 1, 2021 through September 30 of 2021. Generally, a person becomes an AEI if they are a COBRA qualified beneficiary who became eligible for COBRA either due to a reduction in hours, whether the reduction in hours is voluntary or involuntary, or whether they had an involuntary termination of employment. So one thing that I think was helpful that the IRS did is indicate that, hey, employers are permitted, they're not required to, but they're permitted to basically require COBRA qualified beneficiaries to self-certify that they are eligible for the COBRA subsidy. In other words, that they are an AEI and that they became eligible for COBRA due to an involuntary termination of employment or reduction in hours. And again, while this is not a required approach, the IRS does recommend this because when you go to take a tax credit, to offset your costs as the employer for paying the COBRA premium on behalf of these AEIs, and if you were to be audited by the IRS, these written self-certifications will be a good method to substantiate your eligibility for the amount of the Medicare tax credit that you received. For those of you that are familiar with the COBRA subsidies, and if you're not, I encourage you to go back and look at some of our previous client alerts and webinars. There's also what we call this extended election opportunity, or second bite at the apple, and that was frankly, required employers to send a supplemental or additional notice to folks who may still be in their COBRA period, but hadn't either hadn't elected COBRA as of April 1, or maybe had previously elected but dropped COBRA before April 1, and gave them a chance to elect COBRA. But when the Department of Labor published the model notices for those people, it also indicated that notice had to go to these AEIs who were enrolled in COBRA as of April 1. And a question that I had is, okay, if someone's enrolled in COBRA and the employer has a reasonable belief or even knows that they became eligible for COBRA due to a reduction in hours, it was clearly a voluntary termination of employment, the employer kind of have to automatically turn on the COBRA subsidies for these folks. And the IRS's response is no. You can send them, this additional notice, and you can wait till they get back a COBRA election with a request to be treated as an AEI before you turn on that subsidy. And just so you're aware, the Department of Labor has published a model form for these AEIs to request that status. It's called a request for treatment of AEI. Employers are also permitted to require potential AEIs to self-certify whether they're eligible for another group health plan or Medicare. And as we'll talk about here on the next slide, if you are an AEI and you're eligible for another group health plan that provides major medical coverage or Medicare, your eligibility for the subsidy will cease, even if it's before September 30, 2021. Other disqualifying coverage. This is what we call another group health plan that provides major medical care or Medicare. And again, if you're eligible for this other disqualifying coverage, you're generally not going to be eligible for a subsidy. The IRS guidance clarified that the individual is eligible for the subsidy, even if the individual was previously eligible for another group health plan before April 1, 2021, but on or after April 2021, was not permitted to enroll in that group health plan. So maybe a good way to explain this is by an example. So let's assume we have an employee who has an involuntary termination of employment back in October of 2020. And so they're potentially an assistance eligible individual, and they are permitted to enroll in another group health plan. Let's say the group health plan by the employees from the employee's spouse's employer. And coincidentally, they were permitted to enroll in that during the open enrollment period with coverage effective January 1, 2021. For whatever reason, the individual declines enrollment in that group health plan. So the question is, okay, they were previously eligible for this group health plan. Are they still eligible for the COBRA subsidy? And in this example is now, since the open enrollment period is done, the individual is not permitted to enroll in that health plan till the next annual open enrollment period with coverage effective January 1, 2022. In this example, the individual would be eligible for the COBRA subsidy from April 1 through September 30, because they were not permitted to enroll in the group health plan effective on or April 1, 2021. But keep in mind that EBSA disaster relief notices 2020-01 and 2021-01 extended various benefit deadline elections. Key to that were those requests to enroll due to a special enrollment event. So if we kind of tweak our example, on October 1, 2020, the employee loses coverage because he has an involuntary termination of employment. That loss of coverage, assuming the employee was eligible to enroll in the group health plan of the spouse's employer, triggered a special enrollment right. That enrollment right under EBSA disaster relief notices typically would have had to be selected by October 30, within 30 days. But that deadline under these disaster relief notices was extended to the earlier of 1 year from the original deadline, or the end of the outbreak period, which hasn't occurred yet. So if we're talking about HIPAA special enrollment event in this, the employee is still eligible to enroll in the spouse's group health plan, right now, because of that extended deadline. And because of that, because they are eligible to enroll in that other group health plan, that would actually make the individual ineligible for the COBRA subsidy, because they would be eligible for disqualifying coverage that they could roll in on or after April 1, 2021. All right. PTC, or Premium Tax Credit Interaction. So for those of you that are familiar with the ACA, You know that if an individual enrolls and purchases coverage through an ACA exchange or marketplace, they may be eligible for a premium tax credit that lowers the premium cost for the employee. And there's really two ways an individual can take a premium tax credit. They can either pay the full premiums throughout the year, and they claim the premium tax credit on their tax return, which is a refundable credit. For some employees, the premium may actually create some cash flow issues, and they can't afford to pay the full premium and wait to be, for the credit on their tax return. So for individuals are also eligible for what they call an advanced premium tax credit. And that tax credit lowers the cost of the monthly premium immediately. And when the individual files his or her income tax return at the end of the year, they basically have a reconciliation to determine what was the actual premium tax credit they were eligible for, how much should they get in advance, and if they were eligible for more, they get an additional credit. If they're eligible for less, they may have to pay a little bit back. So let's talk about how COBRA and COBRA Subsidized COBRA interacts with premium tax credit eligibility, particularly for folks who are getting one of these advanced premium tax credit. So a former employee who's enrolled in COBRA is not eligible for a premium tax credit when purchasing coverage on the AC exchange. That's nothing new. If you've been following along, you probably know that. A current employee who is eligible for COBRA, so they say maybe had a reduction in hours, they're still employed, they're eligible for COBRA with the subsidy, is not eligible for a premium tax credit when purchasing coverage on the exchange. And that's because the offer of subsidized coverage is affordable. And so keep in mind, if you have current employees who may be eligible for the subsidy, and they ask questions, they should be aware that they may not be eligible for that premium tax credit subsidy if they say, no, I don't really want your COBRA, even if it's subsidized, I'm going to go out in the exchange and get private coverage there. The IRS also clarified one thing, I think, which was helpful for those folks that may elect COBRA under this second bite of the apple or extended election opportunity. We kind of assume that, if they elected it, it would automatically be effective as of April 1, 2021. Potentially the individual, if they have their original COBRA deadline extended by these EPSA disaster relief notices, could elect it retroactively, but we'll cover that later. But what the IRS guidance has said, no, these folks who have this second bite of the apple, they can elect it as of April 1, or they can elect it as some prospective date. So for example, the date they make the election. And where that may be helpful is for those folks that previously turned down COBRA because they were gonna have to pay for it, went out to the exchange, got a exchange policy and are getting a premium tax credit. Well, now this says, okay, well, I'm eligible for the subsidized COBRA, but in April and May, for example, I just got my notice, I'm still covered by a subsidized policy, on the exchange. So I can go to the exchange and say, listen, I want to cancel my policy as of May 31 because I can get the subsidized COBRA. So when I turn my election form in my request for treatment as an AEI back to my employer, I'm going to indicate that I want the subsidized COBRA to start June 1, and that will not negatively impact my eligibility for a premium tax credit and potentially require me to pay some back at the end of the year. So COBRA subsidy during extension. So again, for those of you that are familiar with COBRA, you probably know that if you become eligible for COBRA due to a reduction in hours or an involuntary termination of employment, the COBRA period is generally going to be 18 months from the date of the qualifying event. But that 18-month period can be extended really in two circumstances, at least under federal COBRA. There's other state COBRA laws that may extend it further, but we're not going to dive into that, particularly because Michigan, where we're sitting, does not have a state COBRA law. Excuse me. So the first instance is an 11-month disability extension. So if an individual is determined to be disabled by the Social Security Administration, and there's certain rules about when they are determined to be disabled and when they provide, the disability determination award from Social Security to their employer, they may be eligible for an 11-month disability extension. The second one is if you have a reduction in hours or termination of employment, that's an 18-month period. If you have a second qualifying event, that's a 36-month qualifying, a qualifying event that entitles you to 36 months of COBRA, you're going to extend COBRA up to 36 months, again, but from the date of the original qualifying event. the IRS guidance said, hey, to the extent that one of these COBRAs, these extended periods, overlaps with the period of January or April 1, 2021 to September 30, 2021, you're still eligible for the COBRA subsidy, even though 18 months has already expired. As long as the original reason for COBRA was the reduction in hours or involuntary termination of employment. So again, let's say we have a COBRA qualified beneficiary becomes eligible for COBRA due to a reduction in hours, but their 18-month period ends March 1, 2021, a month before the COBRA subsidies are available. But during that 18-month period on January 15, 2021, the qualified beneficiary had a dependent kid who aged out, basically turned 26 and no longer was eligible for coverage. That is a secondary qualifying event. It extends coverage for 36 months measured from the original COBRA qualifying event date, and therefore extended that COBRA period, at least for the kid, through the subsidy period. In that instance, the child would be eligible for the subsidy. Now, this originally raised some concerns for me, because for those of you that are familiar with the second election opportunity, notice you were going back all the way already to October 1, 2019 to try and figure out if you had any employees who had a reduction in hours or an involuntary termination of employment who hadn't elected COBRA, who maybe had elected COBRA and dropped it, to figure out if they needed to get one of these extended election opportunity notices. And so the first question that this guidance raised in my mind is, do you potentially have to go back 3 years from April 21 to identify folks that may have had a reduction in hours or involuntary termination of employment to see if maybe they had an 11-month disability extension or an extended 36-month period due to a qualifying event, and also send them the notice? Fortunately, the answer appears to be no, because there is another Q&A in the guidance that says, in order for the subsidy to be available during these extended periods, an individual would have had to elected COBRA originally and remained in COBRA the entire time. So those folks that never elected, arguably you don't have to look at. But if you have people that are enrolled in COBRA as of April 1, 2021, due to a reduction in hours or involuntary termination of employment, and they're still enrolled under an 11-month disability extension or due to a second qualifying event, you still got to send them that notice and allow them to elect to be treated as an assistance eligible individual, at least for those folks that are eligible during the subsidy period. So again, helpful guidance, a little bit scary, but I think it, if you go on and read on, it does limit an employer's requirement to go identify people for several years ago that may may still have eligible COBRA under one of these extensions. So let's talk about involuntary terminations of employment. Hopefully in most cases, whether termination is voluntary or involuntary is pretty cut and dry. But there's always going to be situations where it's less clear. And so I guess the general rule, as the guidance says, an involuntary termination of employment means a severance from employment due to the independent exercise of the unilateral authority of the employer to terminate the employment, other than due to an employee's implicit, I guess you're mind reading now, or explicit request for termination. But I think what is key here is where the employee was willing and able to continue to perform services. So that's kind of the general rule. The IRS then just dives into a bunch of different fact patterns that I think are helpful. And it indicates that, if you terminate, an involuntary termination of employment occurs, excuse me, when an employer takes an action to terminate the individual's employment while the individual is absent from work due to an illness or a disability, but only if before they took that action to terminate employment, the employer had a reasonable expectation that the employee was going to return after the illness or disability. I actually had an interesting question come off from a client the other day. For disability leaves, they continue coverage for 6 months, and then after that, they trigger COBRA, but they keep folks on staff for at least 15 months before they terminate their employment due to a disability leave. And they had someone that was at the disability leave that had basically was coming up on their 6-month period that they're going to trigger COBRA, but had already indicated, hey, I already moved out of the state. I'm close to retirement. I'm not coming back after this is done. So can you please terminate me, and then I can be eligible for this subsidized COBRA that I hear about? And I said, ironically to my client, I said, if you terminate them, which again, talk to your employment lawyer, about terminating folks that are on a disability leave, whether you have any ADA implications in doing that. But if you terminate this person and you don't have any reasonable expectation that they're going to return, that's a voluntary termination of employment. The individual is not COBRA subsidy. I said, but I think where this is ironic is if you let this person stay on for your full 15 months, like you would normally do, and at the end of the 6 months, when they trigger, the loss of coverage, and you offer them COBRA, that's a reduction in hours. And so if you keep them on at that 6-month period, they're going to become eligible for the subsidy. You terminate them, they're not eligible. You keep them on and they reduce their hours, they are going to be eligible. So I don't know how they ended up working that out, but I thought that was a unique situation with how this guidance worked. Terminations in connection with retirement. So generally a retirement is going to be a voluntary termination of employment, and the individual retires is not going to be an AEI and not eligible for the subsidy. The exception, of course, to this rule is that unless absent the retirement, the employer would have terminated the employee's employment. The employee was willing and able to continue employment. And here's the key, the employee knew the employer was going to terminate his or her employment absent them deciding to retire. If those kind of fact factors, I know that if I don't retire, I don't want to retire, I want to keep working. And if I don't retire, I know that my employer is going to fire me or terminate my employment, or lay me off, then that would rise to the level of involuntary termination of employment, and they would be subsidy eligible. Now, keep in mind, if you offer what we call a window program, and this terminology comes from the FICA tax regulations on on deferred compensation. If you have a window program in which an involuntary termination includes participation by employees with impending terminations of employment, and they're basically offered a severance agreement to terminate employment within a specific period of time, generally no more than 12 months, that is going to be an involuntary termination of employment. But as we will talk about in several slides here, the amount of the severance arrangement is not going to be eligible for the Medicare tax. The amount that you voluntarily, if that severance agreement includes some type of voluntary employer subsidy towards COBRA, that will not be eligible for your Medicare tax to offset these COBRA subsidies under ARPA. Terminations for personal reasons. So, for those of you that watched my original presentation on this, at that time, we were relying a lot on IRS guidance back from 2009 when they previously allowed very similar subsidies. And the IRS addressed that and also in question and answer format in 2009. But that was due to the Great Recession, as folks probably remember. So we didn't have all these situations where things were closing due to a pandemic. So we were really hopeful that the IRS guidance this time around would address some of those situations that were very unique to the COVID-19 pandemic. And fortunately, they did. I think, unfortunately, for some employees, it's not the answers that they necessarily wanted to hear. So involuntary terminations of employment generally do not include an employee's termination to general concerns about workplace safety. Okay, I don't have any specific reasons why I'm concerned to go to work. I'm just generally afraid of maybe contracting COVID. That's not going to rise, and so I'm terminating my employment. That's not going to rise to the level of involuntary termination of employment. And keep in mind, we're going to talk about an exception to that rule. Departures due to personal circumstances, such as school and daycare closings. I can't go to work because someone's got to be at home for my kids. If I terminate employment due to them, due to that, not an involuntary termination. But if potentially you don't actually have a termination, you may have a reduction in hours, which is going to be subsidy eligible event. If both the employer and employee intend to maintain the employment relationship and they're going to come back as soon as kiddos can go back to school, back to daycare. do not include terminations due to concerns of an employee's or family health concerns of the employee or family member, or the inability to find daycare. Now, really, in any of these situations, if the employee is able to substantiate that the involuntary termination of employment was due to the employer's failure to take an action, or failure to take an action or provide a reasonable accommodation, rises to the level of a quote unquote constructive discharge, then it may be an involuntary termination of employment. Unfortunately, the IRS guidance gives no idea on what this definition, at least in this context, of a constructive discharge may mean. Now, and again, if you get a request for treatment by one of these folks as an assistance eligible individual, and you disagree and you said, well, that's voluntary, you're of course going to deny that. The employee then can basically make a quick appeal to the Department of Labor, and if they get involved, they may tell you it's an involuntary termination employment and they are eligible. And I realize you may want to avoid the Department of Labor getting into your business, but keep in mind, it's not necessarily just the conservative approach to say, oh yeah, it is involuntary if it's not truly, because if it's not involuntary, but you just kind of treat it as it to go along and get along, and you take the tax credit and you're later audited by the IRS, and the IRS says, no, that was voluntary termination of employment. That amount of the COBRA subsidy that you provided, we're disallowing that from your Medicare tax credit. Of course, if you could have the Department of Labor that kind of overruled your decision, that would be great substantiation that was an involuntary termination of employment and you were eligible for that credit. Involuntary reduction in hours. So this is actually, I thought, was somewhat interesting. So if you have an involuntary reduction in hours that does not cause a loss of coverage, it may still be an involuntary termination of employment if the material reduction in hours is treated as a termination for good reason. Again, this kind of doesn't rise to the level of a constructive discharge. Where I think this could pop up is, let's say you have an employee that's, you use the measurement stability periods to determine an employee's full-time status. And if an employee switches, from full-time to part-time during a stability period in which they're full-time, you may continue their coverage at least till the end of that stability period to avoid an ACA pay or play penalty. This is saying, hey, if I'm an hourly worker and my hours get shifted to way down, so I'm not making near as much money, but I still didn't, I still was entitled to coverage at the same cost. That's not a COBRA qualifying event, so it's not a reduction in hours, but it may be treated as an involuntary termination of employment. And therefore the COBRA subsidy may be available. Now, again, the fact that it didn't, even if it was an involuntary termination of employment, if it didn't cause a loss of coverage, I'm kind of a little bit questioning how that's going to work. Hopefully this is a rare situation, but maybe this is one of the areas that the IRS will provide additional guidance on, because if you don't have a loss of coverage, whether it's a termination, involuntary, voluntary, or a reduction in hours, it's not a COBRA qualifying event. So what I think this kind of shifting gears here is what benefit plans or what benefits are eligible for the COBRA subsidy. And it's basically any benefit that's eligible for COBRA, with one notable exception, is medical flexible spending accounts. So it includes, obviously major medical group coverage, prescription drug coverage. It also includes dental only and vision only coverage, HRAs. And then for those of you that have employee assistance programs that provide medical care, such as they have a limited number of counseling sessions, those also appear to be subject to COBRA, and coverage under those, the cost will be eligible for the COBRA subsidy and therefore the Medicare premium tax credit. Now, what's interesting and I think a little bit frustrating is, let's say you have an employee terms employment on February 1, 2021, due to an involuntary term. They were enrolled in medical, dental, and vision. You sent them the COBRA election. They elected medical right away. They did not elect dental and vision. Well, you arguably had to send them this extended election opportunity as of, notice. Because they were enrolled in group medical as of April 1, and they're a potentially assistance eligible individual. But also, if you look at the dental only and vision only, they were eligible for COBRA but hadn't elected yet. And so those folks maybe could they could potentially elect dental and only or dental and vision coverage as of April 1 or prospective date. They potentially could also elect dental or vision only coverages back to the qualifying event under the EBSA disaster relief notices that extended those election deadlines. So, what I think you're gonna see, and we're gonna talk about another slide, is really, when people elect under this extended election opportunity, they're ultimately going to have to specify what date they want COBRA to start. Brett, do you have a question in the queue here?
Yes, Tripp. So we have our first question today, and this question says, if the employee voluntarily moves from full-time to part-time and is offered group health plan coverage at an increased cost, is the employee potentially eligible for the COBRA subsidy?
That is a great question, and the answer is yes. And it all centers around what is a loss of coverage for COBRA. And so here, let me back up. It depends. Do we have a COBRA qualifying event? In order to have a COBRA qualifying event, we have to have a quote unquote loss of coverage due to a specified reason. Here, the specified reason, reduction in hours, check that box, we're good. Now the question is, do we have a loss of coverage? We're still offering that individual coverage. But if you look at the COBRA regulations, it's basically any change in how you would offer coverage to the similarly situated non-COBRA qualified beneficiary. So in this instance, because the premium is going up, that is a loss of coverage triggering COBRA. So that appears to be, this individual appears to be assistance eligible individual who is eligible for the COBRA or eligible for the subsidy. Now, what's interesting is, if you arguably should be sending them a COBRA election notice, when this change happens. If they elect COBRA, clearly they're going to be eligible for the subsidy. If they decline COBRA and continue to enroll just at the increased cost, I'm not so sure that they're enrolled in COBRA coverage, and because they're not enrolled in COBRA coverage at that point, the subsidy would not be available. So you certainly have a potentially assistance eligible individual. Well, let me take this back, Brett. This is a great thing that I just thought about. Because remember, if you're eligible for disqualifying coverage, you're not eligible for the subsidy, right?
That's right.
And so this individual has a qualifying event, reduction in hours, creating a loss of coverage. It's an assistance eligible individual, but they immediately become eligible for group health coverage under the same plan. So maybe in that situation, you would not be eligible for this. You would be an AEI, but you'd immediately be eligible for disqualifying coverage. I think this is one that you may want to explore carefully. If you have different, additional questions, you want to talk this through, because there's obviously some moving parts there. But that you could see that was a great question, and unfortunately not one that, to my recollection, was addressed in IRS guidance. I'll have to take a look at the reduction in hours, but my thought is potentially those folks would not be eligible because they're eligible for disqualifying coverage. One more question?
Yes, we also have one more question. This question asks, are quote unquote no call, no shows considered voluntary or involuntary terminations?
I've gotten that question a lot. And I think if you go back to the definition of involuntary termination, in that instance, the employer is using their unilateral ability or authority to terminate the individual's employment. Now, I guess the maybe question is, are they willing and able to continue working? I think potentially those folks are still assistance eligible individuals. The immediate following question I get after that, which I haven't gotten in a while, is, well, what is it gross misconduct? And can I treat it as gross misconduct? Well, keep in mind that gross misconduct is not a new concept with respect to COBRA now that the subsidies are available. It's a much more popular one, but it's always been around. And remember, if your termination of employment is due to gross misconduct, you're not eligible for COBRA at all. The problem is there's no bright line test for gross misconduct. It really is dependent on what, the kind of the court has said in your jurisdiction, but it's generally a pretty high threshold. And I think no call, no show, it would be aggressive to say that was a gross misconduct. So I think potentially that may be an involuntary termination of employment, unless you can, kind of substantiate that the employee was not willing and able to return to work at all. It's again, those are tough ones, and the IRS guidance did not, unfortunately, address that issue either. Switching coverage options. So one thing that ARPA also did is said, hey, for AEIs, you can allow them to switch your coverage option, under this extended election opportunity, if they're already enrolled in COBRA, from one medical plan option to another medical plan option. But if the legislation said you can only switch to a lower cost option. So what the government didn't want is saying people realizing, hey, I can get this free COBRA. I'm going to, and I elected coverage under my employer's cheap high deductible health plan because that's what I was at. But they also have this gold Cadillac plan with zero deductible, zero co-payments. And now I can get that free. I'm going to elect that and it's more expensive. Not so fast. You can't do that. Now, if the employer allows that, you can do it. But what the IRS guidance says, if an AEI switches to a coverage option that is more expensive, the COBRA subsidy just goes away. It's not even available to those folks. So you can't have the employee or the AEI say, I'm going to switch into that higher cost coverage option and just pay the difference. Now, keep in mind that is not necessarily always going to be the case. If someone goes through an open enrollment period, during the 6-month period of April 1 through September 30, they can always then, just under normal COLA rules, elect any other medical option that's offered to similarly situated participants. So if they, at an open enrollment, elect a higher cost medical option, that's not a switch under ARPA. That's a switch just under normal COBRA rules, and the ARPA subsidy would still be allowed. Question, Brett?
Yes. This question asks, if an individual is eligible for other coverage, but does not enroll in the other coverage, such as coverage through another employer, and that individual is receiving the subsidy, will this disqualify that individual from the subsidy? And also, how can employers police this?
Great question. So again, it's eligibility for other disqualifying coverage is going to make you cease to be eligible for the premium tax credit. It's not necessarily enrollment. Now, it's basically from the effective date, though, so you can't factor in the waiting period. So if I become eligible to enroll in coverage as of June 1, but I have a 30-day waiting period, so that coverage, that other group health plan coverage, not going to be effective until July 1, I'm eligible for the subsidy until July 1, regardless of whether I enroll in that other coverage or not. Now, keep in mind, as we talked about, at the earlier part of this presentation, if I don't have an opportunity to actually enroll in that coverage effective on or after April 1, 2021, then it's not going to be disqualifying coverage. As to how an employer polices that, there is a question on the DOL's model form that asks the employee to respond and says, are you eligible for other group health coverage, or are you eligible for Medicare? If they check no, it appears that you can rely on the employee's attestation or that answer that question, unless you have knowledge otherwise. For example, in the question that we just got about the reduction in hours, where they were eligible for coverage, immediately, but at a higher rate from their same employer. Again, remember, you can also have employees self-certify that. Now, I think doing that in addition to making them request, turn back this model DOL request for treatment as an AEI form is probably redundant, but you could go through that and when they make that election, basically make them certify that they're not eligible for coverage. And remember, we'll talk about in a few minutes, employees that are required by this law to notify you. And if they don't notify you that they become eligible for other disqualifying coverage, they could be subject to a penalty unless the failure to notify was for a reasonable cause. So COBRA elections under ARPA. So as folks notice, the COBRA, or may be aware, we've done some client alerts and webinars on this. COBRA election deadlines, and we've actually mentioned this in webinar a few times, the normal COBRA election deadlines were extended under ABSA disaster relief notices 2020-01 and 2021-01. And basically that said, the election deadline is extended till the earlier of 1 year past the original deadline, or if earlier, the end of the outbreak period. And the outbreak period ends 60 days after the presidentially declared national emergency for COVID-19 ends. Well, the presidentially declared emergency for COVID-19 hasn't ended yet. I don't know when it is going to end. So right now we're still operating that these extended deadlines are probably going to last for at least a year. The IRS guidance said that, hey, these extensions do not apply to elections under ARPA, those 60-day election periods. So if I get the extended election opportunity notice, I have 60 days from receiving that notice to make my election under that notice. That 60 days is not extended. An AEI who has a qualifying event that is a reduction in hours or involuntary termination of employment between April 1, 2021 and September 30, 2021 must elect COBRA in the request to be treated as an AEI within 60 days of that COBRA election notice. Again, that 60-day period is not extended. Now, what's interesting is that the IRS guidance says that really only applies to the COBRA assistance, though. The actual election to elect COBRA is still going to be extended by these disaster relief notices. So maybe an example is I have an involuntary termination of employment on May 1, 2021, and I get my COBRA qualifying election notice that day. If in order to get the COBRA subsidy, I have to elect, COBRA and request to be treated as an AEI within 60 days, which is what, July 30, July 31. If you, June 30, 60 days from May 1, June 30, you have to elect. Now, if I elect COBRA after June 30, I won't be eligible to get the COBRA subsidy, but under the extended COBRA election deadline, I could still potentially elect COBRA. So what happens at the end of September 30, 2020 for those folks that are still getting the COBRA subsidy, their eligibility hasn't ceased earlier. And again, in addition to being eligible for other disqualifying coverage, the subsidy is going to end when your normal COBRA period ends. So assuming that this September 30 deadline is not extended by future legislation, COBRA is going to automatically continue. You're not just going to disenroll these AEIs from COBRA because the subsidy ended. But they are going to have to start paying the premium for COBRA after September 30. And if they fail to pay the COBRA premiums, then of course COBRA will terminate just like it would normally. Now, keep in mind, the payment deadlines are still being extended by ABSA Disaster Relief Notice 2020. So, if the COBRA election or if the COBRA premium for October is due October 1, you get a 30-day grace period. So it's due October 30, 2021, assuming that the COBRA, these extended election deadlines last for a while yet, you potentially have until October 30 of 2022 to pay that COBRA premium. Again, circling back to these extended election opportunities under ARPA, if a COBRA qualified beneficiary incurs an involuntary termination of employment within 18 months before April 1, 2021, but is not elected as a COBRA as of April 1, 2021, the individual, of course, can still probably elect COBRA under the original COBRA election period. And we've kind of touched on this. Because those are extended by the disaster relief notices with no gap in coverage, or they can say, hey, I don't want coverage before April 1, 2021, because I know I have to pay for that. So they can decline to elect COBRA under this COBRA original election period, and instead elect COBRA as of April 1, 2021, or some other prospective date. Remember, they could do it going forward. And basically only have COBRA beginning with free COBRA. Now, what the IRS guidance says, hey, once the person, 60-day period from getting this extended election opportunity, notice expires, if they elected to decline retroactive coverage back to the date their qualifying event, they can't change their mind. And that's true even if the original COBRA election period is still open under the disaster relief notice. So if I, let's say my termination of involuntary termination is March 1, 2021. I get my and I haven't elected COBRA, I get my extended election opportunity on May 1, 2021. I really have at that point the opportunity to elect COBRA back to March 1 with no gap. I could elect it effective April 1. You know, if I elect it back to March 1, I have to pay the COBRA premium for March. I could elect it as April 1, no COBRA premium. But if I'm enrolled in individual coverage, maybe I want to elect it as of July 1 so I can disenroll from my individual coverage where I'm getting a premium tax credit. But once you make that election and that 60-day period expires, which again is on June 30, and say I hadn't elected it back to March 1, I can't change my mind and still elect it back to March 1, even though my original COBRA election is still open based on these disaster relief notices. I realize this is confusing. And back when we had these COBRA subsidies in 2009, we didn't also have these extended periods. So this is just kind of another layer of complexity that we've added on already, the complexity of these extended deadlines. The amount of the Medicare tax credit, it's basically generally amount that the COBRA qualified beneficiary, the AEI, doesn't have to pay due to the COBRA subsidy under ARPA. And that includes the 2% administrative fee, but also going to include the 50% administrative fee during the 11-month disability extension. Now, keep in mind, if you are voluntarily subsidizing COBRA, so for example, through a severance agreement, the amount of your voluntary subsidy is not eligible for the COBRA subsidy. Really, that is somewhat logical. If I involuntarily terminate someone and I say, here's your severance package, you get to continue salary for 3 months, plus for 3 months, I'm going to subsidize your COBRA so that you're paying the same for COBRA as you would have paid for coverage had you remained an active employee. You can't then say, ooh, they passed ARPA. I can shift that financial obligation of me agreeing to subsidize COBRA off to the federal government. You can't do that. You're not going to be eligible for the Medicare tax credit. Now, there are some planning opportunities you can take advantage of. The IRS guidance says you can actually say, nope, if that's kind of my typical practice in the involuntary termination normal case, I'm going to change and say, I'm going to charge you the full premium, but to make up for the fact that I would have normally subsidized your COBRA in addition to your severance payment, I'm going to add on a taxable payment that was equal to what my subsidy have been, but you have to pay the full COBRA premium. If you go that route, the IRS guidance actually says, no, you are eligible for the full subsidy amount as a Medicare tax credit. So if you're providing some voluntary severance benefits that include continued health coverage at a lower cost due to an employer subsidy, keep in mind there is some planning opportunities there to maximize the amount of your Medicare tax credit. Finally, as we know, as I hinted at before, if an AEI becomes eligible for disqualifying coverage, another group health plan or Medicare, they have an obligation to notify the plan or really the employer or that employer's COBRA third-party administrator of their eligibility for that other disqualifying coverage. If they fail to do so, they will be subject to a penalty. The penalty is generally $250. If it's an intentional penalty, it could be 110% of the amount of the assistance, the COBRA subsidy that they get, but that's going to be collected on the individual's 1040. In that situation, unless the employer has actual knowledge that they weren't eligible for the COBRA subsidy, the employer is going to remain eligible for the Medicare tax credit. All right, we got a couple of questions previous to during the registration process that I want to address. One is an employer terminated employee voluntary. The terminated employee said it was involuntary and wants the COBRA subsidy. Who is right? I think it goes back to the facts and circumstances, which we don't have in this situation. But if you truly believe it was a voluntary term, then you obviously they would still be eligible for COBRA, but you would deny them the eligibility for the COBRA subsidy. Keep in mind they could elevate this, appeal, if you want to call it, to the Department of Labor. I think there's if you look at the Department of Labor's model notices, there's information that they can call to get DOL help. The DOL may give you a call and say, listen, this individual contacted us. Here's what they've presented us with, or the facts. We believe that either you are right or the employee's right if these facts are right. And if the Department of Labor overrules you, you may need to provide the subsidy. And if they've already paid the COBRA premium, you can potentially credit that to their future COBRA that they will have to pay for, or issue them a refund. How do we report credits on the 941? That is a good question. I think you'll have to wait till you see the 941s come out exactly. But essentially, you're going to have to report the number of AEIs, the folks that are getting the COBRA subsidies on the 941, and the total amount of the subsidies that you paid for these folks during the quarter that the 941 applies to. And that will be treated as though it was a payment or a deposit. And to the extent that that increases your payments or deposits into the Medicare tax system over what you owed, it will be issued as a refund. And of course, just like any other refund, you can either get that back in cash or you can apply it to your future Medicare tax. Now, keep in mind, if you're encountering some cash flow issues, the guidance has also said, you can offset your deposits of federal income tax, of I believe Social Security tax, both employer and employee share, and Medicare tax, both employee share. You can offset your deposits by the amount of your anticipated credit, and that should hopefully relieve some of that cash flow. You can also file a form 720 or 7200, I believe it is, and ask for a refundable credit back quicker. Keep in mind, it does take the IRS some time to process that. And if you withhold your deposits and that causes you to be underpaid, you will not be assessed an underpayment penalty to the extent that the underpayment relates to these COBRA subsidies. So you ought to be careful not to withhold too much out of your deposits. And I think actually, if you, from a cash flow perspective, just to be safe, if you can wait and reconcile this all in the 941, that's probably advisable. When does the grace period extension for payment of COBRA premiums under the 2020 Act expire? I actually think this is in relation to the deadline extensions under EBSA disaster relief notices 2020-01 and 2021-01, and they will expire again at the end of the outbreak period. That ends 60 days after the presidentially nationally declared disaster for COVID-19 ends. We don't know when that's going to end, so it's hard to predict when these kind of extensions will expire. So it's 1 year, the earlier of 1 year from the original deadline or the end of the outbreak period, which we don't know yet. Brad, I see we have another question in the queue.
Yes. So Tripp, I believe you addressed this question in your previous response. But if an employer believes that an individual's termination should count as voluntary and the employer does not send a COBRA election notice or packet, but the employee believes that it should be an involuntary termination, what does the employee need to provide to the employer in order to attempt to claim the COBRA subsidy?
Well, they're probably going to they may call the Department of Labor, they may do some Googling and stumble upon this assistance or request for treatment as assistance eligible individual form on their own and fill it out and mail it to the employer. I'm not so sure that the employee has to provide anything more than the form. That's at least going to let the employer know that they've got this terminated employee out there who thinks their employment was involuntarily terminated. I mean, arguably the employer or somebody at the employer should know the facts and circumstances around the termination of employment, and they're going to have to look at those facts and circumstances, maybe in light of some of the guidance provided both by the DOL, but more specifically by the IRS, and determine if they agree with that. And if they don't, I think they're going to have to respond and say, no, we don't agree. Your termination was voluntary based on our understanding of the law, and you're not eligible for the assistance, the COBRA subsidy, because you're not an assistance eligible individual. Probably say it more eloquently than that, but keep in mind that they may, the individual may further push this up through the DOL appeals process, and you may hear from the Department of Labor. With that said, it looks like we're almost at an hour. We don't have any other Q&As in the question and answer, so let me thank you again for joining us this morning. This is hopefully this has been helpful to you folks. And again, if you want to look at this again later, or maybe I went too fast, the slides and the PowerPoint those slides will be available on our firm's COVID page, and there will be a link on the COVID page to the YouTube page that this video will be posted later. With that, I hope everybody has a great day and a great Memorial weekend, and we will talk to you all again soon.